Hello, everyone. Good evening. Welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you're enjoying our legal education content. Please remember to subscribe. Today, we're dealing with a recent decision from the Sixth Circuit Court of Appeals relating to bump stocks. So, for those of you who are not familiar with this, let me tell you a little bit about what a bump stock is. So, a firearm, when it fires a projectile, there's a lot of energy going from the muzzle, right? There's a lot of energy going this way. And we know from Newton's laws of motions that for every action, there's an opposite and equal reaction. So that means a lot of energy going this way means a lot of energy also going this way towards the rear of the gun. And what the bump stock does essentially is it uses the recoil of the gun to automatically or to re-pull the trigger to essentially create a automatic like kind of response. And I say automatic like because it's not as fast as an automatic is. And when a true automatic would be several times faster than this, but it's obviously faster than manually pulling the trigger. Well, actually, strictly speaking, it's not even faster than manually pulling the trigger. A person could do this themselves with their own manipulation. It would just get more tiring. So it would be able to do what a person could do, and therefore is not as fast as an automatic weapon. So anyways, it's a piece of equipment that enables this response. And there was a question as to whether or not this is legal or not, right? Whether or not this device that is turning a semi-automatic weapon into a faster firing semi-automatic weapon is illegal or not. And the ATF under the Trump administration took the position of banning these bump stocks. They said that these were illegal. Now they did this by regulation. What they did is they amended the ATF's regulation, right? They didn't change the statute. They simply changed the regulation. The regulation said is legal, now says is illegal. Okay. So that's the thing that happened. And then of course the question is, can they do that? So we're going to read this. We're going to read this opinion and learn about what it has to say and what the rationale of the court is, and probably read the dissent too, so we can learn a little bit from that. Should be fun. Let's get started. This is from the Sixth Circuit Court of Appeals, Gun Owners of America, Gun Owners Foundation, and an organization that I was a member of and even an executive member of and even a legal advisor to for many, many years, the Virginia Citizens Defense League. So I know them very, very well. So I'm glad to see them here. Matt Watkins, Tim Harmson, Rachel Malone, Gun Owners of California versus Merrick Garland, the DOJ, and the ATF. Great. The question before us is whether a bump stock may be properly classified as a machine gun under the relevant law. But this case rests as much on who determines the statute meaning as much as what it means. Yeah, so this is going to get into Chevron, right? This is going to get into Chevron and who can determine what the statute means. On December the 26th of 2018, the Bureau of the ATF promulgated a rule that classified bump stocks as machine guns, reversing its previous position. So incidentally, when you're thinking about what is a machine gun, for example, for that matter, what is a gun of any description? You can obviously define gun or by various laws and various things, and components might be thought of as the gun itself in some situations. So the idea that the bump stock could at least theoretically be a machine gun by some legal definition, even though it's only a piece of plastic, is not inherently absurd, because you could theoretically define machine gun in such a way as to include it. I mean, it's just a legislative definition, right? Or it's like by machine gun we mean this random piece of plastic. I mean, theoretically you could do that, right? Plaintiff appellants, 3 gun rights organizations, 2 individuals who own bump stocks, and 1 individual who would purchase it if not for the final rule, filed a motion for a preliminary injunction to prevent the final rule from taking effect. After finding the ATF's interpretation was entitled to Chevron Deference, which not surprising, the district court held the final rule's classification of bump stocks as machine gun was a permissible interpretation of the law. Accordingly, they denied it. Yeah, so we've talked about Chevron many times, and basically Chevron Deference says as long as the agency's rule is a reasonable interpretation of the law and is not flatly contradicted by the law, they allow it. So that means that the ATF, and for that matter, pretty much every administrative agency, can actually completely flip their opinion, because the answer to any question might be yes or no reasonably, right? If you have something that's ambiguous, it could be yes, it could be no. So either answer might be correct, depending on how you want to answer it that day. And so even where they flip themselves around, the courts say, well, the statute doesn't contradict it, and either yes or no would be a reasonable interpretation. So how about either answer you want? So we can just change it by executive fiat, because Chevron, which is not a case I'm a fan of. If you've been a member of this channel for any length of time, you should know that. Because an agency's interpretation of a criminal statute is not entitled to Chevron deference, so says the majority, and because the ATF's final rule is not the best interpretation, as opposed to a plausible interpretation, we reverse the judgment and remand. So this court is going to say Chevron does not apply because this is a criminal statute. All right, let's give that a go. Okay, I don't need to go through a long history. Of all that, of the history of machine guns. I don't care that much, because where are we now is the only thing I care about, right? Though there are different versions, all bump stock devices are designed to assist the shooter in bump firing, a technique that increases a semi-automatic firearm's rate of fire. The bump stock replaces a standard stock of a semi-automatic rifle, that is, the end of a rifle that rests against the shooter's shoulder. In contrast to a standard stock, which is stationary, the bump stock is a sliding stock that enables the firearm to move backwards and forward in a constrained linear fashion. So the firearm is moving backwards and forwards within the frame of the stock, as opposed to the stock being fixed. To initiate bump firing, the shooter pulls the trigger once, firing one shot while maintaining consistent forward pressure with a non-trigger hand on the barrel shroud or foregrip of the rifle. At the same time, the shooter also maintains constant rearward pressure with his trigger hand while keeping his finger stationary. The recoil energy from the fired shot causes the firearm to slide backwards at approximately 1.5 inches. The forward pressure applied by the shooter's non-trigger hand, along with recoil channeled by the bump stock, causes the firearm to slide forward. As the firearm slides forward, the trigger bumps against the shoulder's their figure, causing the trigger to depress and the firearm to shoot again. So the bump stock assists this, but ultimately it's the finger that's pulling the trigger. So if you remove your finger, it wouldn't work. Which is also different, so that's notable. At the same time, the shooter, the recoil energy, we read all that. The second fired shot creates this recoil energy again, which again causes the process to repeat. And then the process would continue indefinitely as long as there's rounds and as other things might apply. The cycle will continue until the shooter moves his finger, fails to maintain forward pressure, the firearm malfunctions, or the firearm runs out of ammunition. As with any semi-automatic weapon, the trigger must be completely depressed, released, and then reset before it's capable of firing another shot. Right? One pull of the trigger is one shot. So you have to completely reset the trigger in order to do it. This is why it is will you review Kavanaugh v. Bartlett? I'm not familiar with the case. There's a case called Kavanaugh v. Bartlett. As with all the trigger must be pulled. Only one shot is fired each time the trigger is depressed. The bump stock enables the shooter to complete this depressed, release, reset cycle of a trigger faster than would otherwise be possible with a bump stock. Though the bump stocking firing technique has been around for as long as there have been semi-automatic firearms, the first patented bump stock device was invented only 20 years ago. So the technique was used without the stock as well. In 1998, Williams Atkins applied for a patent for an apparatus for accelerating the cyclic firing rate of a firearm, which is how these all are named. Atkins received patent number whatever and named his device the Atkins Accelerator. Very nice. In March of 2002, Atkins asked the ATF whether it would classify this thing as a machine gun. After some initial confusion, the ATF confirmed that the accelerator does not constitute a machine gun, nor part or parts designed and intended for use in converting a weapon into a machine gun. So this part does not convert a weapon into a machine gun, which seems very reasonable. It might assist you in some way of firing a semi-automatic rifle, but it doesn't transform the gun into a machine gun in terms of its mechanical apparatus. In 2006, the ATF opened an investigation and by its own admission overruled its previous decision that the accelerator was not a machine gun. The agency concluded that the internal spring made the device a machine gun, but stated if the owners removed the internal spring, that would render it not machine gun. So if they remove the spring so the thing doesn't assist in this way, then it's not a machine gun anymore. Atkins sued, arguing that the agency's reversal was unreasonable, the reversal violated due process, and the statutory definition of machine gun was unconstitutionally vague. Kobe Johnson asked, assuming a person owns a bump stock prior to the new regulation, does the possession of the stock after the promulgation of the regulation immediately become a punishable crime? Not necessarily immediately. It would be in the regulation when it would go into effect. So the regulation itself would say it would go into effect, either immediately or X days after it goes final. So the regulation itself would provide that detail. Will someone, Kimberly Mother Rots, will you do me a favor? Will you look up and see whether Kavanaugh v. Bartlett, this super chat, will you see if this is an actual legal opinion? And if so, can you find me a citation for it? Just check on Google Scholar and see if it's a thing. And let me know. Meanwhile, between 2008 and 2017, the ATF issued classification decisions concluding that other bump stock type devices were not machine guns, primarily because the devices did not rely on internal springs or other similar mechanical parts to channel recoil injury. But as with the Atkins accelerator, the ATF later reversed course on these non-mechanical bump stocks too. And then the court puts a footnote here. Oh, it's 2013, thank you. The court puts a footnote here. A bump stock device is not needed to facilitate bump firing. Rubber bands, belt loops, and even shoestrings can all facilitate this and create the same firing mechanism. On October the 1st of 2017 in Las Vegas, Nevada, a gunman from a 32nd floor hotel room fired onto a crowd of people and used, at least in some cases, a bump stock. President Trump directed the Department of Justice to clear all available resources as expeditiously as possible for the purpose of notice and comment, banning the device. On March 29th of 2018, the Department of Justice published a notice of proposed rulemaking that reinterpreted the terms single function of the trigger and automatically, as would be used in the statute in order to classify bump stocks as a machine gun. Over 186,000 comments were submitted. That's a lot. On December 26, 2018, the ATF published a final rule classifying bump stocks as machine guns. The final rule rescinded the ATF's prior classification layers permitting non-mechanical bump stocks and held that all bump stocks must be either surrendered to the government or destroyed as of March 26, 2019. So in this case, it looks like the thing said it was a 4-month leeway in answer to Kobe Johnson's earlier question. So he had 4 months after it became final to comply. All right, procedural history. Plaintiffs filed suit the same day the final rule was published. The claim the final rule violated the APA, the Fifth Amendment's taking clause, presumably because property is no longer illegal, and the 14th Amendment due process clause. Plaintiff appellants also sought preliminary injunction. The district court denied this. The court found the ATF's interpretation was entitled to Chevron, which, is pretty reasonable because Chevron goes pretty far, unfortunately. And the final rule's classification of bump stocks is a permissible interpretation, which I'm sure it is, because permissible interpretation can go pretty far. While appealing the denial of the preliminary injunction, plaintiff appellants moved to stay the effective date of the final rule. We denied the stay, as did the Supreme Court. The final rule did take into effect on March 26, 2019. So the final rule took place, so yeah, it became illegal as of that date. Okay. Below us is the appeal of the district court's denial of the request for a preliminary injunction. All right, so blah, blah, blah. All right, before determining whether ATF interpretation of the statute prevails, we must determine what deference, if any, we give to its interpretation. Plaintiff appellants argue that agency's construction is not, or should not be, entitled to deference when construing a criminal statute. We agree and conclude Chevron deference does not apply to judicial interpretation of statutes that criminalize conduct, that is, imposes criminal penalties. Because the definition applies to a machine gun carrying criminal penalties, we cannot grant Chevron's deference. And then there's a footnote here. The agency also argues the ATF waives reliance on Chevron. Good luck with that. And the ATF agrees, taking the position that because its interpretation is the best interpretation, deference is unnecessary, so it does not rely on Chevron. But we find and hold Chevron deference does not apply in this case anyway, because it doesn't apply to criminal statutes. We need not consider or decide the issue of a waiver. Cool. Chevron might not actually apply to something. That might be nice. In what turned out to be a landmark decision, Chevron versus National Resource Defense Council introduced the concept of Chevron deference. An agency's interpretation of a statute is entitled deference from the courts. Chevron is rooted in a background presumption of congressional intent, that Congress intended delegated interpretive authority to an agency by enacting a statute with capacious terms rather than plain terms. Yeah. Despite becoming the most advanced cited administrative case of all time, Chevron did not appear at first to be a major decision. That's very, very true. No one realized what it was when it first happened. That a third of its members were sidelined due to recusals of some people, so only 6 members of the court were sitting, reduces the likelihood the court intended to make a tectonic shift in administrative law. They probably didn't intend that, but yeah. Regardless of its intent or lack thereof, Chevron did indeed do that. Under the two-step process, here's what Chevron held. First, applying the ordinary tools of statutory construction, the court must determine whether Congress has directly spoken. So if Congress is clear, it's clear. But if the statute is silent or ambiguous with respect to a particular issue, the question for the court is whether the agency's answer is based on a permissible construction. Any permissible construction, even if those constructions completely contradict prior constructions, which drives me completely crazy. Because that's not how it works in court land, right? That's not how it works in judicial branch land. Even if there's multiple different interpretations of a statute, it's not like one court can say X and then just later say, oh, not X. There's precedent and stare decisis. With these concepts apparently have no value to the executive agency. So they can just change their mind anytime. Could you imagine if court cases worked that way? Lord have mercy. Restated a bit more succinctly, the questions are, if a statutory provision is ambiguous, and if so, is the agency permissible? If both steps are satisfied, the court defers. Later in Brand X, the court explained that Chevron deference means agency construction is paramount to even prior judicial consideration. So the executive agencies get to overrule the courts. Thus, an agency may overrule court precedent. Yeah. The executive can just overrule court precedent because Chevron. Does this sound broken to you? It should sound broken to you. The Chevron court was clear and unequivocal. Yeah, unfortunately. When a court reviews an agency's construction of the statute which it administers, and the statute is silent, the court may not substitute its own conclusion for the reasonable interpretation made by an agency. Chevron did not draw any distinctions or identify any exceptions. On Chevron's own terms, I suppose that's true. But in 2014, the court said we've never held the government reading of criminal statute is entitled to any deference, in a case called Appel. Never and any are absolutes, and the court did not draw any distinction, add any qualifiers, or identify any exceptions. A few months later, in Abramsky, the court quoted the same statement when rejecting a petitioner's argument that the ATF's former construction of a criminal statute should inform the court's decision. The Abramsky court can explain. The critical point is we think that criminal laws are for courts, not for the government to construe, which in this case would be the executive. We think ATF's old position is no more relevant than its current one, which is to say not relevant at all. Yeah, what ATF thinks about the law is super interesting and all, but, courts interpret the law. When the government interprets a criminal statute too broadly or too narrowly, a court has an obligation to correct the error. Here, nothing suggests that Congress, the entity whose voice does matter, limited this probation any way that it proposes. So the court, at least in 2014, said twice this, right? They said it twice in 2014, in a case called Appel and a case called Abramsky. They had this language. Okay. Unless the court was mistaken in those two cases or exaggerating for effect, that bold, absolute statement means none of the court's prior cases applied Chevron deference or any deference to an agency's interpretation of a criminal statute. This merits some discussion. Starting with Chevron, which is not a criminal prosecution. It wasn't. The EPA was the defendant. Chevron was just an intervener in implementing the Clean Air Act, which created a permitting program for statutory sources of air pollution and delegated that program to the states. The EPA promulgated regulations allowing the states to adopt a plant-wide definition of the term stationary stores. Okay, so just as a recap, to remind you all what Chevron was actually about, and we've covered this before on my channel, but Chevron was, okay, so there was a regulation under the Clean Air Act, and it basically said that a source of pollution could only pollute so much. And so then it became a question of what is a source of pollution, right? So there were a couple different competing, so in the case of like a coal factory or a coal power plant, there were like two major interpretations. One interpretation was, well, each individual smokestack is a source of interpretation, right? The smokestack could be turned off, it could be turned on, more stacks could be added, more stacks could be deleted or removed, right? So every stack is a source of pollution. And then some states wanted to say, no, actually, the source of pollution is the plant as a whole. And the reason that you'd want to do this is because the regulations that would then apply to the plant as a whole. So you can't get around it by like making every single stack like just under the pollution limit. And then the whole plant as a whole is spewing out so much energy because the sources are so close to each other, right? So some states said, okay, what we want to do is instead of every stack as a source, we want to say the plant as a whole is a single source. So we don't care how many stacks you have or not. We're going to treat the entire plant as a source. So this was the debate, you know? And then, of course, in Chevron, they said, yeah, you can do whatever you like. So, you know, that was that. That was Chevron. The NRDC sued, and the question presented was whether the EPA's decision to allow states to treat the pollution-emitting devices within the same grouping as though they were within the same bubble or same source was a reasonable construction of the term stationary source. What is a stationary source? Is it each individual stack? Is it the plant as a whole? You know, what is it? After creating this aforementioned deference, the court determined that EPA's definition was permissible with respect to the ambiguity, describing it as an effective reconciliation of two ends of reducing air pollution and protecting economic growth. To be sure, the Clean Air Act contains criminal penalties for, among other things, such as false reporting and tampering with monitor devices, a permitted facility's knowing violation of its permitted requirements, but the Chevron opinion contains no reference to the Act's criminal provisions, nor did the case concern possible criminal sanctions. Yeah, it was just like, what is a source? So there was no criminal sanctions implicit in that, really. No reasonable reading of Chevron could stand for the proposition the government's interpretation of a criminal statute is entitled to Chevron deference. When the court intended to silently exclude the criminal provision issue or merely did not consider the criminal provision issue that was not before it, Chevron easily falls within the case's proclamations in Appel and Abramsky that has never held the government's reading of a criminal statute is entitled to deference. Abramsky. I'll try to remember that going forward. The court's traditional approach under the modern non-delegation doctrine has been to allow the courts to delegate to the executive branch responsibility for defining crimes, but only so long as it speaks distinctly. The clear statement rule reinforces a horizon separation of powers and compels Congress to legislate deliberately and explicitly before departing from the Constitution's traditional distribution of authority. Obviously, Chevron, which applies only where there's statutory ambiguity, is the opposite of a clear statement. In Babbitt, the Endangered Species Act made it a crime to take an endangered species, and Department of Interior's regulation said that a taking included the modification or delegation or degradation of a species habitat. So it's a crime to take the species, therefore it's a crime to degrade their habitat. Sweet Home sought declaratory judgment. The statute did not impose that regulation, making the regulation invalid. The court did not employ Chevron, though it cited Chevron's generality, announcing it owns some degree of deference, due in part to the latitude the act is given. Thus, the court appears to have been relying on the clear statement rule of delegation of authority to the Department of the Interior as if the Department of Interior were Congress itself. The court also included a footnote addressing the rule of lenity. So the rule of lenity is a well-known common law doctrine that any ambiguity in a criminal statute goes to the defense, right? So it's like if there's multiple different interpretations of criminal statute, the one that's most favorable to the defendant is the one that wins. And this emphasized that was not reviewing a criminal prosecution, but rather a facial challenge to administrative regulation, which did not necessarily involve this rule of lenity, because it's not a criminal statute, right? Just because the governing statute authorized a criminal enforcement. While Babbitt certainly cited Chevron and used the word deference with regards to the Department of Interior, Babbitt did not discuss or decide whether Chevron applied, nor did analyze the challenges using Chevron, just as it did not decide whether the rule of lenity applied to or analyzed the challenge using the rule of lenity. The best one that can say is that Babbitt, the court deferred with scarcely any explanation to an agency's interpretation of law that carried any penalties. Babbitt's drive-by ruling, in short, deserves little weight, with Scalia saying this in a denial of cert. So not binding authority from the Supreme Court, but while Babbitt certainly mentions deference, it did not hold an agency's interpretation of criminal statute. He is entitled to Chevron deference and follows the court's proclamations in April and Abrahansky that ever held sold. United States versus O'Hannigan, the Security Exchange Act, had criminalized fraudulent trading, which included the use of material, non-public information concerning a pending tender offer. And the Securities and Exchange Commission's rule said that such trading was illegal, even if the trader owed no duty to keep that information secret. When the government convicted O'Hannigan of this, he argued the conviction was invalid because the rule was invalid because SEC had overexceeded its rulemaking authority. The court rejected the argument, finding the statute expressly delegates definitional and prophylactic rulemaking authority to the SEC, and explained because Congress has authorized the SEC to prescribe legislative rules, we owe SEC's judgment more than mere deference or weight. Although the court concluded deference for the proposition it must accord the SEC's assessment controlling late unless it's arbitrary, capricious, or manifestly contra to the statute, it did not conduct a Chevron analysis or present this as a Chevron defense. So, yeah, here the court was distinguishing it from Chevron and saying, well, Congress has explicitly delegated, at least that's the conclusion, Congress has expressly delegated to the FEC the ability to define some criminal things here. And so Chevron doesn't apply, although it might provide some comparators. The court's analysis relied on statutory delegation of authority under the SEC rule to make a clear statement. While O'Hannigan uses the term deference, it cannot be read to support the proposition the agency's interpretation of a criminal statute receives Chevron deference. O'Hannigan falls within the court's promulgation in Appel and Abrahansky that it never so held. We're not aware of any other Supreme Court opinions that would question the promulgation of Appel and Abrahansky, but there are opinions that are consistent with it. In at least 3 other cases, the court has indicated the rule of lenity, the practical opposite of Chevron, which it pretty much is, right? If the rule of lenity is you must interpret the statute in a criminal statute, you must interpret the statute as is most favorable to the defendant. Chevron is kind of the opposite, because in Chevron it's like, well, any interpretation will do. Also, presumably, the interpretation that's least favorable to the defendant. So yeah, it is kind of the opposite of the rule of lenity. The rule of lenity is the most favorable to the defendant. The Chevron rules, how about any interpretation, including the one that's least favorable? Considered altogether, if we take the court at its word, it is never held the court must necessarily grant Chevron deference to the government's interpretation of an ambiguous criminal statute. More to the point, for our present purposes, we're aware of no Supreme Court opinion that compels us to apply Chevron deference to the ATF's interpretation. All right, so based on what they're saying, I think their reading of the law is plausible. I'm not sure if it's correct or not. And if the Supreme Court takes certiorari on this, I guess we'll find out if it's correct or not. But it does seem that, at least, and the Supreme Court themselves said that they never had held any time that criminal statutes should be held to Chevron. So if you had any sort of ambiguity in reading these opinions, right, if you were a little bit unclear about what it means, the Supreme Court themselves saying, we have never in any case held any statute, criminal statute, is subject to Chevron, right? That statement seems pretty clear on its face. And so if there's ambiguity in these cases, you would read it in light of that statement. That makes sense, right? I mean, you wouldn't read it the other way because then the Supreme Court would be wrong. The Supreme Court can't be wrong, right? So, yeah, this looks like a pretty plausible legal interpretation. Our review of the Sixth Circuit precedent reveals we generally do not apply Chevron deference to administrative agencies' interpretation of a criminal statute, as we've explained. The special deference required by Chevron is based on expertise of an administrative agency in a complex field of regulation with nuances perhaps unfamiliar to the federal courts. Unlike environmental regulation or occupational safety, criminal law and the interpretation of criminal statutes is the bread and butter of work of federal courts. Right? So that makes total sense. Unlike regulating the environment or regulating the water, where the court probably doesn't have any special expertise, when it comes to criminal law, the court has special expertise. We can handle that. Considered as a whole, the Sixth Circuit precedent appears to provide us with no controlling authority as to whether we must or must not apply it. So the Sixth Circuit doesn't have anything on this either. So we're going to invent something. To be sure, in equivocal Quiana versus Lynch, which I'll just call Lynch from now on, we relied on Babette to apply Chevron deference to the Board of Immigration Appeals' interpretation of an immigration statute with both criminal and civil penalties. But the Supreme Court reversed that decision based on alternative analysis, and in doing so, expressly refused to decide the applicability of Chevron deference. Right? So the Sixth Circuit had previously said, well, we should apply Chevron, but the Supreme Court said, nah. So thus our opinion in if equivocal or Lynch is therefore mostly persuasive, because the Supreme Court expressly refused to decide the applicability of Chevron. So therefore our prior case is only informative at this point rather than binding. Makes sense. Our reasoning in Lynch was that the Supreme Court had said we must follow Chevron in cases involving board's interpretation of immigration laws. But the Supreme Court has not issued similarly on-point opinions involving the definition of machine guns, which would be a little bit weird. The most analogous precedent is Thompson, Center Arms Company, in which the court applied the rule of lenity, which is give it to the defendant, not Chevron, which is whatever the agency wants it to be, to statutory definitions in the National Firearms Act. Just want to say, for the 112 of you who are currently watching, thank you for being here as always. Really appreciate you being here. I hope that we're all learning something. I'm learning a lot of things. We're learning a little administrative law today. This is more administrative law than Second Amendment law, but there's a little Second Amendment in there too. Stuff to make everyone happy, right? Excuse me. And we never held that Chevron applies to an agency's interpretation of a purely criminal statute, such as the ban of possessing a machine gun. Instead, we found a court's deferring to an agency's interpretation of a criminal statute would be problematic, if not prohibited, because it would lead to probably ex post facto reasoning, because you're not changing the statute. So, since Appel and Abriansky, other federal courts have split as to whether those opinions mandate that a court may not, or merely permit that it need not, defer to an agency's interpretation. So there's a question, can we defer or not at all? And some courts say no, and some courts say if you want. We are not the first circuit court to review the ATF's final rule on bump stocks. The 10th and DC circuits have each concluded that an administrative agency's interpretation of a criminal statute is entitled to Chevron. So the 10th and DC have concluded interpretation of a criminal statute is entitled to Chevron. Both those courts found themselves bound by circuit precedent of an agency's interpretation. The DC Circuit found that in securities context, it frequently grants Chevron deference to the SEC, notwithstanding the violation of laws also trigger common liability. However, as we discussed above, we have no comparable precedent. And in fact, our precedent suggests the opposite. Circuit split. And as mentioned, there's already a split among the circuits on the meaning of Appel and Abriansky, and where the Supreme Court now requires courts to not give any deference to agencies' interpretation of criminal statutes. With this decision, we are joining one side of the split, not creating a split. So yeah, there is a circuit split on this question about what it means. What do these Appel and Abernathy cases mean? Does it mean that we can't defer? Does it mean we can defer? Or does it mean we must defer? Well, those are three very distinct options. We can't do it, we can do it, we must do it. We're not sure. So there's a circuit split. And usually circuit splits are a pretty good indication the Supreme Court is going to take a role, right? So there's a circuit split. Usually a pretty good thing. So if the Supreme Court was looking for a twofer, right, we can do a twofer. We can do some Second Amendment law, and we can also modify/repeal Chevron as a bonus. That'd be nice. That'd be a twofer. That'd make me very happy. We can say the bump stocks are not illegal because the statute doesn't make them illegal, which makes me and the Second Amendment people happy. And then we can say, oh, by the way, Chevron is dead, which will make me actually even more happy. I really, really hate Chevron. I love firearms a lot, but as to bump stocks specifically, I could take it or leave it. I could take it or leave it. So at least for me, the bump stocks being legal will be nice, but the Chevron being overturned, if it should come to be, if wishing made it so. Maybe it will. Having found the Supreme Court and the Sixth Circuit precedent neither requires nor forecloses a specific holding, we turn to the merits of the question. Chevron deference is typically justified on two rationales. An agency is more likely a generalized court to determine the best interpretation, even if it's completely contradictory to other ones that they've held in the past, because of the specialized expertise in the subject matter. And by employing ambiguous terms rather than clear specific language when drafting a statute, Congress ostensibly was deliberately delegating lawmaking responsibilities to the agency. Whatever the merits of either rationale with respect to the civil statutes, neither holds water with respect to criminal. Civil and criminal are in fact very, very different animals. Further deference to an administrative agency's interpretation of a criminal statute directly conflicts with the rule of lenity, right? And raises serious constitutional concerns. Astronaut K says maybe you could amicate. I could write an amicus brief. That's not the worst idea I've ever had. That'd be fun. We can have the Uncivil Law amicus brief. That's a nice idea. It's expensive though, so we'll need to crowdfund it. I'm gonna need just on printing costs alone, because they require this special size paper. And you really don't want to do it yourself. You really want to have it professionally bound so it looks nice. I'm going to need probably $10,000. The printing costs are ridiculous. So we might have to crowdfund for the printing. I was like, I need $10,000 just for the printing. But maybe. Criminal laws reflect the moral judgments and expertise of a community. Yeah, that's kind of what criminal laws do, basically. Practical agency expertise is one of the principal justifications behind Chevron. The Supreme Court's position has been that agencies are more likely to get the answer right, given their expertise, even if those answers completely contradict other answers they've previously given. For example, the court's justification of giving Chevron deference to the Social Security Administration's interpretation of the Social Security Act was because of the related expertise of the agency, the complexity of the administration of the statute, and the careful consideration the agency gave the question over a long period of time. Notwithstanding the ATF's frequent reversals on major policy issues, that alone does it for me, right? Notwithstanding the ATF's frequent reversal on major policy issues. And also, this is not an ATF problem. This is all the agency's problem. So I just don't think you can just say notwithstanding the reversals like it's nothing. When Congress passed a statute, presumably it had some things in mind. And the scope of that is open to debate, right? Like the scope of any statute. It's open to debate. What did Congress mean when it wrote Provision X, right? So what did Congress mean when it wrote single source, right? That's what the courts are for. So if Chevron's like, what did Congress mean when it wrote single stack or single source? They had something in mind. And the ATF can say, well, here's some opinion we have. I have no problem with the ATF having an opinion. They're more than welcome to submit an amicus like anyone else. Be like, here's what we think based on our expertise. I don't even have a problem if the court wants to give them like First Nation status of amici. Like there's such a concept, but we'll make one for them. We'll give them priority consideration as an amici. But I think, here's a bold position I think. You ready for this? I think at the end of the day, courts should be the ones that interpret statutes, rather than the executive agencies who, if they were to interpret a statute a particular way, it might increase their power. Right? So Congress creates a statute that an administrative agency deals with. If the agency interprets it one way or another way, right, that might increase their power. One might think that this incentive may somewhat corrupt their neutrality in their consideration of which interpretation is best. Should I apply this interpretation, which gives me less power, or should I apply this interpretation, which gives me more power? I don't know. I'm completely disinterested. I'm a neutral person. So I'm just going to neutrally consider it, not like I have a manifest reason for interpreting it one way or another. You know? So I think the executive agency's opinion is nice, but I think maybe courts should be the ones that determine what the law means. Because the courts don't have any particular incentive for it to be one way or another. They don't get more power by interpreting it one way or the other. They're disinterested. So I think that makes a lot more sense than the executive, just me. But that technical knowledge is in opposite to the question of what should be criminally punished and what should not. Yeah, your technical expertise is not particularly informative as to what should be legal. Criminal statutes reflect value-laden moral judgments of the community as evidenced by elected representatives' policy decisions. In democratic society, legislatures, not courts, are constituted to respond to the will and consequent the moral values of the people. Right, which is also why courts should not be legislatures. They should be courts and merely interpret what the legislature has said. Criminal punishment represents the moral condemnation of the community. Since our country's founding, it has been understood the public is both capable of and necessary to the determination of the right of wrong from legality and a moral perspective. Indeed, our criminal laws continue to reflect public moral judgments. Our criminal laws, for example, incorporate gradations of punishment to account for moral culpability of defendant and severity of the crime. Yeah, we see that a lot of times, and murder is perhaps the best example because there's so many different versions of it, right? Depending on your state, murder 1, murder 2, murder 3, voluntary manslaughter, involuntary manslaughter, first, second, third degree manslaughter, right? Criminally negligent homicide, vehicular homicide, as some examples, right? So that's a good example because it comes in so many different flavors because a person is dead, but the moral condemnation level is not the same. And legislatures have long recognized that we as a community condemn and punish a premeditated murder more harshly than one committed in the heat of passion, which in turn is punished more severely than one due to negligence. The training for such policy determinations does not come from graduate school education or decades of bureaucratic experience. Rather, one develops the expertise necessary to make these moral judgments from sources more humble and local, one's family and one's upbringing. And then everyone presents their collective opinion, and the consensus hopefully represents what's on the page. This leaning is further informed by relationships with friends and neighbors, the practice of one faith, and participation in civic life. That this education is accessible to anyone and everyone further enhances, not diminishes, the legitimacy of these judgments. After all, we are supposed to be a government of the people, so something that's accessible to all the people is a good thing. And what the Supreme Court has previously said about a federal court's ability to create a crime is equally relevant to a federal agency's ability to do so. Because criminal punishment usually represents the moral condemnation of the community, legislatures and not agencies should define criminal activity. Moreover, mastery of a field does not mean mastery of all fields. That's true. Once you go outside your lane, you can get into problems. And you should be humble when you go outside your lane, and I try to be as best as I can. The ATF is not an expert on community morality. So the rationale deferring to an agency expertise on this question doesn't make any sense. And there's a great risk in responsibility of making moral condemnations is assigned to bureaucrats in a nation's capital who are often physically and often culturally distant from the rest of the country. Having lived in D.C., I can assure you that is very true. Federal criminal laws are not administrative edicts handed down upon the masses as if administrators were God delivering the Ten Commandments to Moses on Mount Sinai. Word, preach it. Whether ownership of a bump stock device should be criminally punishment is a question for our society. And if that ever happens, then we can get into the Second Amendment analysis of that, and that might be an interesting discussion, but that is definitely for a different time. Indeed, the Las Vegas shooting sparked an intense national debate on the benefits and risks of these bump stocks. And because criminal laws are rooted in the community, people determine for themselves through their legislatures what is right and what is wrong. The executive enforces these determinations. It is not the role of the executive, particularly the unelected administrative state, which is really who's doing this. The unelected administrative state is real. This is what Trump, I think, was talking about when he talked about the deep state. This is what I think Trump was talking about when he talked about the deep state. He's talking about the unelected bureaucracy because the unelected bureaucracy stays there forever. Administration after administration after administration. So if that's what he meant by the deep state is very, very real. Whether that's good or not is a whole other subject of question, right? So you could defend it as good, right? Because you have the same people there, and so you have consistency, and if Congress is ever unhappy about it, they can always change the law. So maybe it's good, maybe it's not, but it does exist, right? The stakes of a determination are significant. Under the ATF's final rule, every bump stock owner will potentially face not only a loss of liberty in the form of incarceration, but also the stigma and hardship that accompanies a felony conviction. But whether the loss of liberty and stigma whether bump stock owners, heretofore law-abiding citizens, because you just turned them into non-law-abiding citizens, right, should now be potentially subject to substantial fines, imprisonment, and damning social stigma is a question whose answer and expertise in firearms technology contributes nothing. Yeah, your ability to be a super duper expert in all the firearms and how they work and different components and the technical aspects of firearms doesn't really read on the ultimate question of whether these things should be legal or not. I suppose it, for you, makes your opinion a little bit more informed, or maybe a lot more informed. And you can, of course, share your expertise with others, and so they can become more informed, but we're a democratic society. So ATF's firearms expertise is not germane to the question of whether bump stokers should be condemned and punished. I think that makes sense from first principles, right? We're a representative democracy. Whether something should be legal or illegal is best left to the legislature because they're politically accountable. You know, makes sense. Maybe don't let the executive branch interpret their own laws. Finally, to the extent the ATF is not determining what the agency thinks should be punished, but is instead merely interpreting what Congress has already decided should be punished, that determination also wrongfully relies on expertise the ATF lacks. Rather, as we've already explained, interpreting criminal statutes falls within the expertise of the court. That's what courts do. Indeed, we judges are experts on one thing, interpreting the law. Right. So the rationale of deferring to an agency's expertise doesn't apply. Yeah, when you're thinking about who is best equipped to interpret the law, who has the expertise on that issue, right? The judicial branch. Of course, that's what they do with their time. You are king shits when it comes to firearms. We are king shit on reading laws. We don't want to figure out what firearms are, and we don't want you to interpret our laws. Yeah. In some, for criminal statutes where the primary question is what conduct should be condemned and punished, the first rationale of Chevron deference, deferring to an agency's expertise, is unconvincing because the agency's technically specialized knowledge does not assist in making what is ultimately a value judgment. Knowing what firearms are backwards and forwards doesn't really help you to value it. The judgment is best reserved to the people through their duly elected representatives. That's kind of what that branch of government is supposed to do. And Congress, Congress could probably, actually legislate more and not defer so much and not be lazy, because they keep shoving it. They keep giving the executive branch more power. They could not do that. That'd be really helpful. Deference in the criminal context violates separation of powers. The Chevron court justified deference on the principle that statutory ambiguity represents an implicit delegation to an agency to interpret a statute which it administers, which when it comes to criminal law isn't true. The ATF does not administer criminal law. That would be the Department of Justice. According to the Supreme Court, Chevron thus provides a stable background rule against which Congress can legislate. Statutory ambiguities will be resolved within the bounds of reasonable interpretation, not by the courts, but rather by the administrative agency. Courts ostensibly know Congress is deliberately intending to delegate some of its legislative responsibilities because Congress knows how to speak in plain terms when it wishes to circumscribe and capacious terms when it wishes to enlarge agency discretion. See, I don't have any problem with that part of it. I just have a problem with the conclusion that follows, right? The premise is Congress knows how to use narrow language when it wants to use narrow language and knows how to use broad language when it wants to use broad language, right? And if Congress wants the power of the agency to be narrow, they'd write the statute that way. If they want the statute to be broad, they'd write the statute that way. So I don't have any problem with that, right? I don't have any problem with that. My problem is the scope of that should be left to the courts. So narrower language would suggest a narrower scope. Broad language would suggest a broader scope. It would suggest broader limits, but limits nevertheless, right? So there's some limitation in there somewhere. Maybe it's not very much. Maybe it's a whole shit ton. Maybe it's even nearly limitless, depending on how Congress writes the language, right? It could be nearly infinite. At which case, the courts interpreting it would say, well, geez, it's nearly infinite, so basically you can do whatever you want. But that's the interpretation of law. It's the interpretation of the limits, right? It's not saying, well, you say it's limitless, so therefore we'll say it's limitless. It doesn't really work for me on a logical level. Notwithstanding Article 1's mandate that all legislative power shall be vested in Congress, the Supreme Court has permitted Congress to delegate some of its lawmaking responsibilities to the executive branch agency, so long as Congress provides an intelligible principle which an administrative agency is directed to confirm. Scalia had a more interesting perspective on this, because Scalia said it was wrong to think of it as legislative delegation, because he said there was a good hearing on this that he gave. There's no such thing as unlawful legislative delegation, because there's no such thing as lawful administrative delegation. The Congress cannot delegate its authority, period, in any circumstance. But that being the case, right, the executive has to have rules. And so I'll paraphrase what Scalia said. He said, they have to determine operating hours, whether they'll open the doors. They have to determine, whether there should be fees on grassland or so much so forth. So their ability to administer, right, is not quite the same thing as creating the rules, right? They have to be able to create rules. And then Scalia said, he wouldn't really get into the issue of whether it was too broad or not, for Congress to specify. So if Congress wants to give them a lot of leeway to administer the rules, that's not quite the same thing, at least in Scalia's point of view. It's not quite the same thing as giving them legislative authority. It's giving them executive authority. It's just giving them wider executive authority. So that's how Scalia put it, for whatever it's worth. Scalia didn't think that looking at it as a delegation of legislative authority made sense. He thought you should look at it as merely the expansion or contraction of the executive authority, which Congress has the right to do. And he said he wouldn't get into it, if Congress wrote a statute. And then one of the senators asked this really kind of funny question. The senator said, so what about in an extreme hypothetical where Congress creates a statute that says there shall be a Bureau of Good Laws. The Bureau of Good Laws shall create all the laws that are good for our nation. And Scalia said, okay, you got me. He said, I do that one, but I wouldn't do anything that's plausible. I love Scalia's sense of humor, man. He was a fun guy. And what if we create the Agency of Good Laws? The Agency of Good Laws shall create the law. No, I'll stop you on that one. But anything realistic, no. I like that. That's funny. The court is of the opinion that our increasingly complex society, replete with ever-changing and more technical problems, Congress simply cannot do the job absent the ability to delegate power under broad general directives. That's probably true, and Congress for sure as hell doesn't have technical authority. So, Generally, the Supreme Court has made a clear statement or intelligible principle standard relatively low that they can overcome with fairly indefinite instructions. At the same time, the Supreme Court has made clear that Congress is not permitted to abdicate or to transfer to others essential legislative function if our constitutional system is being maintained. Therefore, a court's deferring to an executive agency's interpretation of a statute naturally raises separation of powers concerns. Yeah. These separation of powers concerns have even greater force in criminal law. Yeah, they do. The separate and distinct exercise of different powers of government is essential to preservation of liberty. The separation of powers serves as a great security against gradual concentration of powers in the same department. In addition to protecting each branch of government from incursion by the others, more importantly, the structural principles secured by separation of powers protect the individual as well. And this was also going back to a nice little Scalia quote from one of his appearances in the Senate, where he said that he thought the most important aspect of the Constitution was the structural aspect, how it was structured. He thought that the amendments were kind of garbage in the end because, you could look at any number of totalitarian powers which have even better versions of our amendments, even more expansive versions of our amendments on paper. How that manifests in reality, though, right? So he's like, in the end, it doesn't matter unless the structure is good. I think he's probably right. Each branch's role and responsibility with regard to criminal law is clear. First, only the people's elected representatives are authorized to make and act a crime. Next, the executive is responsible for enforcing that statute and retains exclusive authority and absolute discretion to decide whether to prosecute any particular case. Finally, it's for the courts to say what the law is, including criminal law. Even under a well-balanced system, the power of federal government, particularly the executive branch, is formidable. No matter how well prepared a defendant may be, his defense will pale in comparison to the resources, institutional knowledge, and personnel available to the federal government. Federal government brings its A game, yeah. If we defer to a federal prosecutor's interpretation of a criminal statute, which would be the next logical step of this, right? The Department of Justice starts interpreting the law and providing regulations on top, right? This imbalance becomes even more lopsided. Whatever separation of powers issues are created by delegation of civil lawmaking, the problems are much more profound when we involve criminal legislation. Specifically, deferring to the executive branch interpretation of a criminal statute presents at least three serious separation of powers concerns. It puts individual liberty at risk by giving one branch both the power to write the law and enforce it. It eliminates the judiciary's core responsibility of determining the law's meaning. And it reduces, if doesn't eliminate, the public's ability to voice its moral judgments because it transfers decision-making from elected to unelected. That's a pretty good argument, right? First, giving one branch the power to both draft and enforce and also interpret. So that's all the things. Enforces criminal statutes it forces the people's right to liberty. The concern over potential abuse of power if the executive can define crimes predates our founding. Maybe it's not such a good idea that they be able to do all those things at once. The executive branch plays an important role in upholding the law and making society safer. But the immense power necessary to achieve these virtuous ends necessarily means the power is at risk of being abused. Yeah, when you give the power to government to do good, they can also do bad. And so we need to have checks to kind of prevent that from happening. Second is for the judiciary to say what the law is, citing Marbury. These words, it's the province of the judicial to say what the law is, are literally etched in marble at the Supreme Court. They're that important. How they could be etched in marble and still decide Chevron the way they decide Chevron is a mystery to me. But we can rectify that anytime, we'll be fine. It is well established that the resolution of statutory or constitutional issues is primarily the responsibility of the courts, notwithstanding the principle. The question of Chevron deference considers whether the judiciary or the executive should have the final say on an indeterminate statute's meaning. Maybe the executive should have the final say on an indeterminate statute's meaning, and then, given that interpretation, should then enforce that interpretation. I don't see any problems with that. Entrusting the interpretation of criminal statutes to the judiciary and not the executive mitigates this risk. Third, because it is potential public's responsibility to determine what conduct should be condemned, only the people's elected representatives have the power to write new federal criminal laws. Indeed, Congress alone has institutional competence. Well, if anyone does, they do, I guess, but democratic legitimacy, and perhaps more importantly, constitutional authority to revise in light of societal problems and preferences. Yeah, two out of those three for sure. Yeah. However, Chevron deference in this context empowers an agency, rather than Congress, to define the scope of what should be criminalized. If Congress were to hand responsibility for defining crimes to relatively unaccountable public officials, very unaccountable, I might add, it would erode the public's ability to oversee the creation of the laws they're expected to abide by, and thus would leave people with no sure way to know what the consequences will be. Of all the separation of powers concerned identified, perhaps this is most troubling. The bureaucrats of an agency are unaccountable to the public. If the agency adopts an interpretation contrary to the will of the people, what resource does the public have? Unlike legislatures, agency bureaucrats are not subject to elections and often further protected from removal by civil service restrictions. Even if an agency implements the will of the public correctly, the determination may still violate separation of powers because the people might change their mind. Because the community has the right to determine what moral wrong should be punished, a practice that predates our Constitution, the responsibility may be entrusted only to the branch most accountable to the people. And it may not be blithely delegated away. Someone standing up for basic principles of liberty here, deep. Because this is good stuff, man. Because such deference in the criminal context would violate the Constitution's separation of powers and pose severe risk, we must hold the agency's interpretation is not entitled to Chevron. All right. So let me take a look at what you guys have been writing and comment as needed. What do we got? It's 50-50 whether size 2A applies to the case like this. But this case specifically doesn't take the 2A into account. Yeah, this case is not a 2A case. This case is not a 2A case. This case is an administrative law case with 2A ramifications. And more like 10-1, Scottus would allow machine gun bans. So you're already convinced that they're going to expand the Supreme Court. I don't think they're going to do it. All right, cool. N Catcher says, thank you for putting this video together. I was late joining. You're welcome. You are very, very welcome. Oh, there was a super chat or something, which let's see if it was still on the pitch. No, I lost it. Maybe it was a super chat from earlier. All right, let's get back to reading. We have established that two principal justifications for Chevron deference in the civil context, deferring to subject matter expertise and respecting Congress's delegation of its lawmaking powers, which I don't really think that's what Congress is doing. I don't think Congress is delegating lawmaking powers. They're delegating regulation authority within the scope of the law, which is not the same thing, in my opinion. I think it's a mistake to look at it as legislative authority. So did Scalia. I think Scalia convinced me. Nor is a third justification for Chevron's deference fit in the criminal context, the background presumption of statutory interpretation that Congress means for federal agencies to resolve ambiguities that it leaves in statutes. Oh yeah, sure, this is for the agencies to define further. Some have suggested this interpretation presumption makes sense in light of traditional mandamus practices. I don't know how that's true. Whether or not true in civil context, the judicial's historic interpretive principles in no way supports Chevron's background principle in this criminal context. To the contrary, ambiguity in criminal statutes has always been interpreted against the government, not in favor of it. Rule of lenity. Yeah. As Chief John Marshall knows, the rule of penal laws are never to be to be construed strictly, or another way of saying that is to be construed narrowly. It's perhaps not much less old than construction itself. So we'd be remiss if we did not acknowledge that Chevron's deference to an agency interpretation conflicts with these most basic principles that go so far back we're not even sure when they were first established. The rule of lenity instructs courts that ambiguity concerning the ambit of criminal statutes should be resolved in favor of lenity, which is to say leniency. Unlike descriptive canons of statutory interpretation that help to resolve indeterminacy about statutes' intended meaning, the rule of lenity is a purely normative canon, rooted in fairness considerations. Although it is not likely a criminal will carefully consider the text of the law before he murders or steals, it is reasonable that fair warning should be given, that the common world will understand of what the law intends to do if a certain line is passed. The rule applies only when, after considering traditional canons of statutory construction, we're left with ambiguous statute. So we have other tools to interpret the statute other than this rule, right? So we can interpret criminal statutes using these other tools. But if we're still left with ambiguity at the end, all points go to the defendant, right? We've long accepted that deference in the criminal context conflicts with the rule of lenity. Yeah, if we defer to the agency that's responsible for prosecuting what they think is prosecutable, that kind of conflicts with this rule. Returning to our prior consideration of Babbitt, we've never considered the rule of lenity should provide for standard reviewing of facial challenges to administrative regulations when the governing statute authorizes criminal enforcement. We must recognize that the Supreme Court has never expressly reaffirmed that footnote and has indeed undercut it in subsequent cases. Yeah, if you are looking at a footnote in the Supreme Court, first of all, anything in a footnote is almost certainly dicta. I mean, I can't think of anything in a footnote that's been controlling authority. So if it's in a footnote, it's got to be dicta. I can't imagine that you could cite a footnote in a Supreme Court case for controlling legal authority. I don't think that makes sense. It might cite to controlling legal authority, but it's not legal authority unto itself. So okay. Moreover, the scope of the Babbitt footnote certainly applies limited. The court admitted there that there might exist regulations whose interpretation of statutory criminalized penalties provide such inadequate notice of potential liability as to offend the rule of leniency, right? But that regulation before it in Babbitt cannot be one of them because the regulation had existed for 2 days, which is enough to apologize, 2 decades, that's a lot of different time, was enough to give fair warning. What if the agency's regulation is not nearly so long-standing? Or what if, in this case, an agency is reversing a long-standing policy? Here, the ATF had a regulation unaltered for 2 decades. Non-mechanical bump stocks were not machine guns. The Babbitt footnote did not specify how long a regulation must be in order to satisfy fair notice concerns or where the standard changes when an agency reverses. Thus, we face a scenario opposite to that addressed in Babbitt. In the end, we need not decide these questions because we find on other grounds, for reasons discussed above, the interpretation is not subject to Chevron. So finally, the summary. Whatever the merits of giving Chevron's deference to an agency's interpretation is civil, and I think, no, the principal rationales behind that policy cannot be extended to supporting given deference to an agency's interpretation of criminal. Triple no. Q squared says, what about the footnote in the case yesterday that essentially explicitly precludes applying all results of that case to virtual presence through online sales and interaction? No, it didn't do that. Maybe I misexplained it, or maybe I misexplained it when I read it, or maybe it's my fault. But what the footnote said was simply we're not speaking to that issue. They didn't say that. They didn't say that. They weren't speaking to the issue at all. So it wasn't exactly them saying that they were precluding the results of this case from applying. They were simply saying we're not going to speak on it either way. So it would be proper in a future case for a court to interpret a electronic issue, internet issue, using this case. So the Supreme Court's footnote didn't prevent that. It just simply said we're not going to deal with that at all right now. We have nothing to say about this, so hands off, right? So maybe I misexplained it, but yeah, it wasn't precluding applying it. It was just simply saying we have no comment on how this might read on the internet land. Someone else can figure it out later. Decline to grant Chevron deference to an agency's interpretation of criminal statutes respects the community's responsibility to make value-laden judgments on what should be criminalized, upholds separation of powers, complies with the rule of lenity, and avoids fair notice concerns. Because the ATF's interpretation is not entitled to Chevron, we must determine the meaning of the criminal statute and where the bump stock falls within it. So now we're going to do something in administrative law that we're not used to doing. We're going to interpret a statute. Whoa! We're going to interpret a statute. Whoa, in an administrative law proceeding? Whoa. What madness is this? Give me 1 second. Okay. It is a fundamental canon of statutory construction that words generally should be interpreted as taking their ordinary, contemporary, common meaning at the time Congress enacted the statute. The separation of powers requires we interpret a statute as written, and we not rewrite the statute simply to accommodate a policy concern, which, Roberts may have done in the Obamacare cases, depending on your point of view. When a bump stock whether it falls within this definition of machine gun is a question of statutory interpretation. And a starting point for any question of statutory interpretation is the language of the statute. That's a good place to start. In determining the meaning of a statute, we have several interpretation tools at our disposal, including contemporaneous dictionaries. This would mean at the time contemporaneous, right? We have the structure and context of the rest of the statute. We can get a meaning of this part from other parts. And descriptive canons of statutory interpreters, such as expressus generis, expressio unius, and nulla os silicius. For following reasons, we find a bump stock does not fall within statutory definition. The parties dispute the meaning of the phrase single function of the trigger in the statute. Plaintiff appellees argue the phrase refers to the mechanical process through which the trigger goes when the firearm is doing, as opposed to what the shooter is doing. The ATF argues, at least for the moment, that means a single pull of the trigger as analogous motions. The ATF claims the function does not refer to the precise mechanical operation of a specific type of trigger, but rather the action that enables the weapon to shoot, the shooter's initial pull of the trigger. Put differently, the question is whether function is referred to a mechanical process, the act of the trigger being depressed, released, and reset, or the human process, the shooter is pulling or otherwise acting on the trigger. So what is one pull of the trigger? Is it the mechanical aspect or is it the human action? Under the former, a bump stock does not fundamentally change the mechanical process. In order for a single shot to be fired, the trigger must be depressed, released, and reset before another shot may be fired, which is what differs it from an automatic weapon. Under this interpretation, the bump stock's attached semi-automatic firearm clearly is not a machine gun and is not capable of firing more than one shot for each depressed, release, reset cycle of the trigger. Under the latter interpretation, the bump stock requires that the shooter pull, as physically bend his or her finger, and apply force to the trigger once. After the shooter pulls the trigger once, the bump stock enables continuous firing to begin and continue without requiring the shooter to physically move his or her finger and pull the trigger again. Indeed, a bump stock is successfully operated when the shooter keeps his or her trigger finger stationary. Under this interpretation, the bump stock's attached semi-automatic firearm would be a machine gun because the firearm shoots mobile shots despite the shooter's pulling the trigger only once. We have not previously addressed the meaning of the phrase single function of the trigger. The district court concluded that both interpretations were reasonable, and because it was operating on Chevron, upheld the final rule. That's reasonable if you're going for Chevron, sure. But having determined not so much, we must decide the best meaning of the statute, right? So both interpretations are permissible. But what is the best meaning? And also the rule of lenity, what is the one that most favors the defense? When interpreting the words of statutes, contemporaneous dictionaries are the best place to start, and also more contemporaneous writings in general, as needed. We began by looking to dictionaries contemporaneous with the passage of the Gun Control Act in 1968. However, the dictionary definition of a function leads to both interpretations. So you see Merriam-Webster from 1967 defining function as action. You see Webster in 1967 defining function as acts or operations expected of a thing and characteristic of a thing. That is to say, because function means action, dictionaries alone do not reveal whether the statute is referring to a mechanical act of pulling the trigger or the physical act of pulling the trigger. We need next consider the phrase in context of the rest of the statute to see if that might illuminate this meaning. Is it used other places in the statute that might be read on this part of the statute, for example? Congress intended when drafting the section. Yeah, Congress was writing it all together, so they kind of probably presumed to mean it as one contemporaneous whole. Statutory interpretation is a holistic endeavor, so we should look at a whole bunch of things. The structure and wording of other parts of the statute can help clarify the meaning of an isolated term. Here, the statutory context weighs heavily in the plaintiff appellee's favor. First, the phrase plainly refers to only the single function of the trigger, not the trigger finger. And if function is meant action, then most natural reading would not be read single action of the trigger to mean single action of the trigger finger. Rather, best, most natural reading would be that refers to the trigger itself. Second, this interpretation is further supported by the rest of the statutory's definition, a machine gun that describes the firearm, not the shooter or the shooter's actions. When we're talking about machine guns, we're talking about the mechanical parts of an object. We are not talking about the person. So it would be a little bit strange to read this section as referring to the person. Nothing in the statute suggests the phrase single action function trigger refers to shooter's pulling of the trigger rather than the trigger itself. Third, the final rule's interpretation that single function trigger means single pull the trigger and analogous motions necessarily refers to the trigger and not to the shooter's act of pulling. Single pull of the trigger. The ATF rule does not interpret the phrase to mean single pull by the trigger finger or shooter's single pull of the trigger. Instead, as with the statute, the final rules refers only to the trigger itself, without any mention of the shooter or shooter's action. Because, again, when we're talking about what is a machine gun, we're probably referring to an object, not a person. Finding that function refers to a mechanical process, we conclude a bump stock cannot be classified as a machine gun under the relevant statute. We recognize a bump stock increases a semi-automatic firearm rate of firing, possibly to a rate nearly equal to that of an automatic weapon. Well, I guess depending on the automatic weapon, maybe, but usually no. With a bump stock attached to the semi-automatic firearm, however, the trigger must still be released, reset, and pulled again before another shot may be fired. A bump stock may change how the pull of the trigger is accomplished, but it does not change the fact that they only shoot once for each pull of the trigger. This remains true regardless of whether the shooter's finger is stationary or is moving, and likewise remains true regardless of whether the physical force depressing the trigger comes from the shooter's trigger finger pushing the trigger or the recoil energy of the firearm pushing the trigger. With or without a bump stock, a semi-automatic firearm is capable of only one shot for each pull of the trigger, and is unable to fire again until the trigger is released and the hammer of the firearm is reset. Indeed, to the extent the Supreme Court has spoken on the meaning of the statute, its interpretation is supportive of the interpretation we have today. So, see Staples from 1994 is used here. The term automatic and fully automatic refer to a weapon that fires repeatedly with a single pull of the trigger. That is, once the trigger is depressed, the weapon will continue to fire until the trigger is released. The Supreme language may not necessarily foreclose the ATF's interpretation, but the court focuses on whether the trigger is depressed and how many times the firearm is capable of firing until the trigger is released, strongly suggests the court's understanding as referring it to a mechanical process of the trigger rather than what a person is doing. Given that the first bump stock type invention was not patented until well after a decade after the most recent amendment, it would be impossible to say definitively whether the 90th Congress in 1968 or the 99th Congress in 1986 would or would not have intended to ban bump stocks, because they didn't exist yet. But the fact that Congress might have acted with greater clarity or foresight does not give courts carte blanche to redraft statutes and to achieve what Congress has perceived as to fail to do. Again, maybe you can look at Roberts on this one, on Obamacare, depending on your interpretation of what Roberts did there. The statutory definition of machine gun, as amended, excludes bump stocks because bump stocks do not fundamentally change the line Congress drew to distinguish automatic firearms. Congress could amend the statute tomorrow. Yeah, they could. To criminalize this bump stock ownership if it wished. Indeed, some states have done that. But we as judges cannot amend the federal law. And neither can the ATF. This is because separation of powers principles require that any legislation passed through the legislature, no matter how well intended or widely supported the policy might be. Yeah, just because everyone wants it doesn't somehow change the process it has to go through. To allow otherwise, it would be to put individual liberty at serious risk. In some, based on text and content of the statute, and any further supported by Supreme Court's interpretation, we conclude the phrase "single pull the trigger" refers to the mechanical process of the trigger, not the shooter's pulling of the trigger. Consequently, a bump stock cannot be classified as machine gun. Seems pretty reasonable. Our holding a bump stock does not fall within the statutory definition of machine gun because a bump stock does not cause a firearm to fire more than one shot by a single action is sufficient to resolve the appeal. Consequently, we need not decide whether the ATF have a better interpretation of automatically. And then we're going to go through the remaining injunction factors. Having determined that they're likely to proceed on the merits, Having determined that they're likely to prevail on the merits, we have to go through the other elements of the preliminary injunction standard. Whether they'll suffer irreparable injury, whether the issuance of the injury will cause harm to others, and whether the issuance would serve the public interest. These standards should sound pretty familiar. The final two factors, assessing harms to others and weighing the public interest, merge when the government is the opposing party. So when the government is the opposing party, those two merge into one. The government conceded in the district court that the plaintiff appellees would suffer irreparable harm. So they conceded that element. As we stated, the final rule will cause bump stock owners to either surrender or destroy their devices or face serious fines. The ATF claims the bump stock ban will further public safety, which may be true, but the claim is undercut by the ATF's admission that there may not have been a number of violent acts committed with bump stocks, notwithstanding the 500,000 bump stock devices in circulation. So whatever problem it causes, it hasn't caused much of one. Without an injunction, plaintiff appellees will suffer immediate, quantifiable, and serious irreparable harm, while the impact of an issuance of an injunction on public safety is only speculative based on the evidence the ATF has provided to us. You know, the benefit of this seems kind of like you're guessing because the history doesn't really seem to expose the problem. Weighing these factors together, we hold the district court should have granted a preliminary injunction, and therefore we reverse. However, we do not decide the scope of the injunction, as say the scope may not exceed the bounds of the 4 states within the Sixth Circuit's jurisdiction, of course, encompass the parties themselves. Though we disagree with the ATF's position, the ATF prevailed in the 10th Circuit on this issue, as well as the DC Circuit, from which the Supreme Court denied certiorari, right? If we were to permit a universal injunction, also frequently called a nationwide injunction, we create an absurd situation in which the ATF must prevail in every single case brought against the file rule in order for its interpretation to prevail. We do not think that's within our authority to do to overrule sister circuit. Yeah, and the entire concept of these universal injunctions or nationwide injunctions is deeply questioned by conservatives. Like, the idea that they should be able to do this in any case is deeply questioned. And we're certainly not going to modify what the conservatives believe in just because it's Second Amendment, right? That's not what we do in conservative land. In conservative land, we try to apply our principles as consistently as possible. And so many conservatives, including this conservative, have long questioned, although we have not necessarily, at least I have not necessarily concluded that it's universally prohibited, but I've definitely concluded in my mind that it's deeply suspect and deeply questionable that they have this authority. And so if it exists in some case theoretically, I am loath to, perhaps use exactly the right phrase, pull that trigger. So as a good conservative applying my principle consistently, I would not apply it here, because whatever exceptional case I'm waiting for, this is not it. Yeah, I mean, the idea of these nationwide injunctions is so unpalatable that I'm not going to change it just because I also believe in the Second Amendment. Try to be consistent, While this will create a circuit split, Kobe Johnson says, if you time when you finish, I appreciate a quick review of the dissent. Just a cursory reading. Yeah, we're going to try to do that as energy allows, because I think what the dissent is going to say, is just kind of emphasize. I think the dissent's case is going to be very similar to the majority case. It's just going to kind of emphasize the aspect that there have been. Apologize again. It's just going to emphasize the fact that there have been civil statutes with criminal penalties, and the Chevron has been applied in those cases. And nothing in the Supreme Court Court's language prohibits it, especially if they've never said that. So I think it's just going to emphasize that. What did I just say? That in the civil law arena, the courts have allowed Chevron even if they have criminal law consequences. So I think that's where this is going. That would make the most sense from the setup, right? But we'll see if that's right. While this creates a circuit split, there's value in having legal issues percolate in lower courts. That's true. Nationwide injunctions limit the valuable percolation of legal issues in lower courts. It's a problem because it prevents more courts from looking at it, prevents more analysis. It also means the Supreme Court is more likely to screw it up. If you have like 5 or 6 circuit courts look at it first, and then you have the Supreme Court look at it, right? That history is helpful to the Supreme Court in trying not to screw it up. The Supreme Court has noted that often permissible to allow several courts to give issue in order to gain the benefit of that. Indeed, Justice Gorsuch, in his concurrence of the denial for certiorari in a Goudas case, stated, other courts of appeal are actively considering challenges to the same regulation. Before we decide whether way we benefit from hearing their considered judgment. Yeah, before the Supreme Court picks this up and fucks it up, let's get other people in their judgment and look at their reasoning so we can figure out what the best reasoning is. The short-term uncertainty and disunity created by this percolation is justified by its producing a more thorough review of the issue. So even though the law is different in different parts of the country, it's nevertheless good because it means the Supreme Court will be more well-informed when it's time to step in. Conclusion. Consistent with our precedent and mandated by separation of powers and fair notice concerns, we hold that the administrative agency interpretation of criminal statute is not entitled to Chevron. Consequently, the district court erred by finding that ATF's final rule, while interpreting the meaning of machine gun, as defined by law, was entitled to Chevron. And because we find single function of the trigger refers to the mechanical process, we further hold a bump stock cannot be classified as machine gun because a bump stock doesn't modify the mechanical process. Accordingly, we find they're likely to prevail in the motion, and the motion for the injunction should have been granted. Therefore, we reverse and remand for issuing the injunction. That makes total sense. So let's skim the dissent real fast. So Chevron applies here. Second framework is not waivable. Third, the Chevron, second, that the idea that Chevron itself is not waivable, I think is probably true. So the idea that the ATF waived it is probably not waivable. That's probably true. The ATF's rule is legislative. The Administrative Procedure Act draws dissension between legislative and interpretive rules. Legislative rules that have the force and effect of law. Interpretive rules do not. A rule is legislative, intend to create new rights, laws, or duties. The ATF rule is legislative within the meaning of the meaning of the Administrative Procedure Act, I guess. It went through this process, blah, blah, blah. Because the rule is legislative, it's of the type where Chevron two-step typically applies. We apply Chevron when Congress delegated the authority to the agency and was promulgating the exercise authority. Congress has expressly delegated rulemaking authority to the Attorney General, and the ATF exercised that through notice and comment. The bump stock rule is firmly within Chevron's domain. Chevron cannot be waived. That's probably true. Yeah, it's a standard of review, not a right or privilege. That's right. You can't waive a standard of review. That doesn't make sense. So yeah, I'm on board with the idea Chevron can't be waived. It's not a right or a privilege. It's just a standard of review. So it doesn't make sense for it to be waivable. That would be like saying that proof beyond a reasonable doubt can be waived. That doesn't even make sense. You can't plead non-guilty and then say, well, it would be roughly the equivalent of you pleading not guilty and the defense attorney saying, well, we don't need this proof beyond a reasonable doubt. We're more than happy with clear and convincing evidence. Now, why a defense attorney would do this, who knows? But you can't do that because the standard is law. It's not your privilege. It's just the law. So you can't say, the prosecutor says, sounds great to me. Ho, 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 let's charge the jury with clear and convincing. Judge be like, fuck you both. The majority concludes that Chevron never applies to laws with criminal application. It discusses relevant case law that leaves the question open and puts forth three normative reasons why it shouldn't apply. I disagree with this. To start, Chevron itself implies agency interpretation that had criminal implications of what a station or a source was. At the time, knowing a violation was punished by a daily fine and imprisonment. Still, court applied the deference. Yes, they did. But it's a little bit, is it different? I think it's different because the statute criminalized knowing violation of the permit requirement. And then it was up to the agency to determine what the permit requirements would be within its. I think it's a little bit different here. I think there's enough nuance to tease out a difference. In O'Hannigan, the lawyer was convicted of 17 counts of the Security Act after engaging in stock transaction based on material non-public information. The Supreme Court rejected the scope of the rule and applied Chevron despite its clear criminal application. Because Congress has authorized the Commission to prescribe legislative rules, we owe the Court a Commission judgment. So they So they are reading the case law differently. Defense, Babbitt, and O'Hannigan also apply legislative regulations issued through notice and comment. If things turn on Chevron, you're going to have a bad time. That's true, Q squared. Very funny. Because these statements were made outside the context of Chevron-eligible interpretation, they do not resolve our question. Whereas Chevron and O'Hannigan and Babbitt control. These cases describe when court has considered legislative rules promulgated through notice and comment as applied Chevron, even when the rules have criminal interpretation. So yeah, they'll probably go for en banc. I don't know what the Sixth Circuit will do en banc. I would not be surprised if the Sixth Circuit grants en banc on this. I don't know which way the Sixth Circuit would go on Monk. I kind of hope that they keep the standard just for the nature of the conflict, so that we can get the Supreme Court to finally do something. Majority recognized O'Hagan and Babbitt's Supreme Court applied deference to regulations of criminal application, but since neither applied Chevron deference. Majority cites U.S. versus Thompson. There was no agency regulation to address the statutory question, so the court never had to choose between Chevron and point of lenity. It's the Supreme Court prerogative, not ours, to deem one of its decisions overruled by implication. That is completely true. Yeah, you can't do that. We saw that in the National Coalition of Men in the draft registration case. Yeah. So yeah, you can't. Yeah, but then the question was whether Chevron applied in the first place in this context, and you have other decisions from the Supreme Court which said it didn't, right? So is it overruling by implication? If the Supreme Court itself says we have never said in any criminal case that Chevron applies, then Chevron itself can't possibly speak to it, because Chevron was decided by that point, right? So yeah, so is it rejection by implication, or did the Supreme Court itself reject it? We're not applying. We view this rule, unpublished opinion from a court, to direct attention. Yeah. Majority rules, rationales against applying interpretation, community expertise. There are many areas where agency expertise is relevant to laws with criminal implications. The dispute here is highly technical. I guess it is in some sense. Morality cannot explain why Chevron is permissible and civil but not criminal. I don't know if that's true. I mean, the idea that criminal statutes, because it comes at a risk of imprisonment and deprivation of your freedom of liberty, as opposed to civil, you can. I think you can just split why morality can apply in civil or criminal but not civil. I think you can split that pretty easily, actually. Separation of powers. Delegation of authority to promulgate rules with criminal penalties to protect the forest. Congress may delegate legislative authority to several. I mean, the minority opinion has their own rationale. Well, the minority opinion looks pretty good. It's a pretty solid reasoning. It's not one of those cases where I look at this and like the minority is reaching. There have been plenty of times of cases where I looked at the minority and I think, yeah, the minority is completely reaching. This doesn't make sense. The minority here is a strong opinion. I think the majority is also strong. I think they're both strong opinions. It's just like, at the end of the day, which you think is better, right? So which you think is more persuasive. But I think the minority has their shit together. So I could definitely see you saying, well, the minority has the better end of it. I could definitely see that. Again, in the interest of being fair, right? I always try to be fair. Just because I like the Second Amendment, right? Just because I like the Second Amendment and the right to bear arms doesn't mean I'm going to be any less fair, right? If I think that the dissent is good, even if the dissent, as a practical matter, is saying no bump stock for you, an end result which displeases me, right? That's not how I do law. I don't look at the end result. I look at the process along the way. So the dissent actually has a very solid argument here. It's pretty persuasive. It's pretty well reasoned. Second Amendment or no, it's like I recognize quality. So, try to remain consistent. Try to give an honest opinion. Chevron provides fair notice about the content of criminal law. Applies only when Congress's directions agency to follow relatively formal administrative procedure tending to foster fairness and deliberation. Importantly, such procedures, while generally include formal public notice, they do not provide an adequate notice of potential liability. The DC Circuit's rationale is pretty good too. If it's a valid legislative rule, all on notice. And that makes sense. I mean, it makes sense within the confines of administrative law as we know it / love it, right? So it makes sense within the confines of administrative laws that exist today. Now, again, if we want to go and overturn Chevron, right, I'm all about it. I'm all about it. I don't think Chevron was correct. I've criticized it many times. I think it's a garbage opinion. Nevertheless, I recognize that it's legally operative. And so once you concede that it's legally operative, because of course it is, and you read this and you read the D.C. Circuit's opinion, you're like, yep, that makes total sense. I may not like Chevron, but it is the law, so, D.C. Circuit has a solid point. Again, try to be fair about it, I'd apply Chevron. Chevron itself follow law of criminal penalties. The only way to get from Ali's binding is to suggest Abriansky and Appelli silently overruled. However, the Supreme Court only may do that. But there's another opinion that kind of speaks to that too, and we certainly made a part of it. Yeah, I think the majority makes a good case. I think the dissent makes a good case. The statute is ambiguous. I think we all can concede that much. The ATF interpretation is reasonable. That we can concede, right? So if we're going to do Chevron, then the ATF's interpretation is reasonable. Not because I want to be, but because it is. And it's Chevron Deference does, and if it is, it's a reasonable interpretation. Yeah, I have no problem with that. So the dissent makes a pretty solid argument. It makes a very, very solid argument. It looks good. This is not crap. I think this is pretty solid reasoning. Good citation of the precedent, good reading of the precedent. There's good reading from the majority as well, and their reading of the precedent. I think both have a fair reading. This is an area of law that is a little ambiguous. And also, there's other circuit splits, right? So it just isn't the Sixth Circuit. There's other circuits who disagree with this, too. So, yeah, there's a split because both readings make sense. Yeah, so, it looks right to me. It looks right as in being valid under its own terms. Not that I agree with it, but it looks like a solid opinion. I understand why people would find that persuasive. Kobe Johnson says, do you think the best way to get rid of Chevron is let the Supreme Court fix it, eradicate it by statute, or pass a constitutional amendment? Well, we definitely don't need a constitutional amendment. That's for sure. Chevron is not a constitutionally mandated rule. That's for damn sure. Eradicating it by statute would have been nice. When Trump came into office, there was a proposal to do that, and I guess it went nowhere, which is annoying. But can the Supreme Court overturn it? Yeah, the Supreme Court created it in the first place, so, So I don't really care if the Supreme Court does it or the legislature does it, but either way, it's fine by me. But we definitely don't need a constitutional amendment. It's not a constitutional mandate. Do I think the majority opinion scholars might be looking to de-emphasize Chevron on some level? That does seem to be the scuttlebutt, yes. The overarching scuttlebutt does seem to be that the Supreme Court is interested in putting some reins on Chevron. Now, how deep those reins go is a whole other issue, but it does seem like the Supreme Court has some interest based on, reading of tea leaves and based on the overall consensus of lawyers. It does seem like the Supreme Court has some interest in modifying Chevron in some degree. How big a modification would that be? Who knows? Will it be a repeal of Chevron? It's kind of unlikely, but one can dream. Mikulek dumped a mag in a semi AR-15 faster than a full auto sear. I believe that. That guy is legend, man. Mikulek, he's absolutely legend. He can do shit with firearms that are truly unbelievable. Silicon Player says it's not reasonable. The triggers function with every single shot. Without our bump stock, it's the same weapon mechanic. Well, Silicon Player, I just think with all due possible respect, I just think you're not being fair to the interpretation, right? I just don't think you're being fair. I think the language can be fairly read either way. And I think, although I couldn't say for sure, I think that it's possible that your views on the Second Amendment might be clouding your interpretation of this language. You want the interpretation to go some way, and so you think that the language can't be interpreted the other way. But, I like the Second Amendment as much as the next guy and have more education on it, perhaps, than many guys. And I think it's a fair reading. I think this, especially in light of Chevron and its many, many, many precedents. Like the scope of Chevron and its subsequent cases, like Reasonable interpretation is pretty damn broad. It's not because I want it to be. I'm just here to tell you what the law is. I don't like it. I'm not a fan of it. I don't want to be this way. I'm just telling you it is this way. All right? The case law on Chevron has been nothing if not expansive. So to say this is not a reasonable interpretation is just, with all possible respect, not faithfully applying the case law. Case law that I don't agree with, but is in fact the law for better or worse. So what do you want from me? I'm not going to give you bad legal information. You know? I'm a legal education channel. I'm not here to tell you. If I know what the answer is, I will tell you what the answer is, even if I don't like it. I will also tell you I don't like it. But like, I'm a legal education channel. I don't have to like it for me to tell you this is the law. You know, this is the law. The agencies get so much latitude. So much latitude. It's pretty freaking rare for when Chevron does apply. It's pretty rare for a court to say, well, their interpretation was unreasonable. It happens, but, you know, not often. So within all the case law that exists, yeah, I'm going to go ahead and disagree with you on this. This is unfortunately reasonable within Chevron, and it's many following cases. Not that I like it in the first place, but, you know, eh. The ATF interpretation means several auto is full auto because it can be bump fired. No, that isn't correct. Because the semi-auto out of the box can't. Well, maybe I'm wrong. Well, if you could bump fire it without changing anything on the firearm, so if you could do it without like any external equipment except for your hands and fingers, then that wouldn't be a fully automatic because you aren't using any equipment. The only thing is whether the equipment is changing the function in some way. So I don't think that's true. No. This isn't Second Amendment bias. You can bump fire a Glock out of the box 15 rounds per second. Bump stock doesn't change that. So it's not reasonable to say it allows mobile shot by single function, not semi-auto itself. I mean, I don't know what to tell you. You can bump. I don't think. Well, agency gets so much discretion, so I don't think that really works. A stick or a belt loop will do it. That's still external equipment. So yeah, if you apply the stick or belt loop to the firearm, then you would then have an automatic within that definition. Yeah. So once you apply the two things together, yeah, then you'd have an automatic firearm within that rating, right? So the components by themselves are not automatics, and also the components in question have other uses. So like it's like a little bit silly to say you can do it with other things. I think I don't I can prove to you can, without any change, every single semi-auto, the bump stock doesn't have that function. Is that a fair interpretation? It's a plausible interpretation, yeah. Because the scope of how plausible is read, yeah, probably. If you can bump stock a firearm with absolutely no external equipment, then you might have a point. If you're using external equipment, I'm not really sure that you're there. It would also be the difference between something having primary use of doing that and a secondary use. So the idea of distinguishing, like, for example, belt loop would be, well, its primary function isn't for that. lots of things can be used for purposes for which they're not designed or their function. So yeah, but the bump stock is primary functions of that, so I don't think that quite works on them. Yeah. I agree with you, but the implications bother me. It's an accessory that's being regulated as an entire firearm. Pistol braces are next. Oh yeah. I don't like the implications any more than you do. Yeah, I don't like the implications any more than you do. And I think you're right. Pistol braces are next. That's logical. Sure. Yeah. I think we're in for some dark days. Can you bump stock a semi-auto with no external equipment? Is that possible? Using nothing more than your hands? There's a meme of a really big dude firing a pistol really quickly. Oh yeah, I mentioned that earlier. Like, you can manually do this. You can manually pull it. You can manually pull the firearm as fast as the bump stock. It just tires the hand. But yeah, that's not quite the same thing as bump firing it. But yeah, you can replicate this with. You can replicate the effect without replicating the process. So yeah, you can replicate the effect of the fire rate, but it wouldn't be a bump stock. It wouldn't be the same mechanism. It's a different mechanism because your finger's moving the whole time. That's different. In the bump stock example, your finger isn't moving. So in the example where you're firing as fast as the bump stock, your finger is moving. So it's different from a mechanical perspective. Yeah, you can put your finger in your belt loop. Put your finger in your belt loop. Well, that's still using external equipment then. I mean, because you're using something external to the firearm. You're using the belt loop. Because now you've connected your belt loop to the gun via your hand. So I don't know that I don't know if that works. Yeah. And again, because belt loops have a primary purpose, other than that, I don't think the ATF can get to them. I think the ATF can only regulate things that have a primary purpose or a significant purpose for firearms. The fact that you can open a beer bottle with like literally anything doesn't make literally anything a tool for, doesn't make anything like a thing like that. It's like, because it's the same. It would be the same idea of saying you could make a bong out of an apple, therefore apples qualify as drug paraphernalia. That doesn't work anymore than this example. It's like, I can make a bong out of a potato, therefore all potatoes are drug paraphernalia, therefore all potatoes can be regulated by the DEA. It's like, no, that doesn't make sense. Yeah, the DEA might be able to regulate things that are designed to be used for that purpose. But if you went into your local head shop and they sold potatoes, I'm not sure the DEA can get to that. Yeah. I don't think that quite works. That logic quite works. Yeah. I don't think the DEA can start regulating grocery stores. So yeah, I don't think that logic quite works. It's like, well, anything could be a bong, therefore everything is a drug accessory, therefore the DEA can ban all the things. No, I don't think it's going to fly. So I don't think it works anymore for the ATF. Well, a belt loop can be used for this. No, I don't think that works either. Yeah, you can make alcohol from potatoes. Yeah. Of course you can. I think the FDA would be all over the head shop. It'd be hilarious. It'd be hilarious for a head shop to sell potatoes just for the meme. That would be fun. They sell like bags of potatoes. There's got to be a head shop somewhere that does it just for the hell of it. We sell potatoes. That'd be great. Yeah, so if you can bump fire it without any equipment, though, you're still not using any equipment. So the firearm, I don't think, because the firearm itself, yeah, but are you really bump firing it? I don't know. But because you're using no external equipment, it's not the same thing as saying the firearm by itself is yeah, if you could do it with your own skill without any external thing, I don't think that's quite the same thing. And also because the ATF can regulate the external tool, right? So it'd be like saying, I don't know what it would be like saying. It'd be like saying, what would be another example of something that you could do yourself if you really want to, that would be illegal, that you could like ban the tool that would do the same thing? I don't know if there is any such regulation, but if it were possible for you to like crack a safe using just the feel of the tumbler, like if you could literally feel it as you were spinning it, if you're that good, if you're that sensitive, and you could do it just by touching it, right? And you could crack a safe, I don't think it would preclude whatever agency from like banning or regulating tools that are designed to crack safes, because a person could do it by themselves. I don't think that quite works, you know? So I don't think a person being able to bump stock a firearm with no external tools, assuming that's possible within the meaning of what we're talking about, bump stock, assuming that's possible, I don't think that quite means that the firearms are semi-automatic, because if you really, really try, you can bump stock without any external tool. I don't think that quite works. $5 from Newbie. Country cards. You can't use a tool, but you can use your mind. Nevada law. Oh, counting cards. Yeah, counting cards. Yeah, sure. Well, it's not just Nevada law. It's just because it's also because you aren't cheating. Yeah, you can, if you can count cards in your mind, you know, it's not illegal. In Nevada, at least, they can deny you play. In New Jersey, they can't. Did you know that? In New Jersey, they can't deny you play for counting cards. It's true. Now, what they can do is they can make your life much harder. So they can change the rules of the game so that it makes the counting cards so harder. So they can add more decks to the shoe. They can shuffle the deck after every hand. Some of them will do that, right? They'll shuffle the deck every hand, right? Or they'll like set a bet limit. They'll say like all your bets have to be the same, so you can't change your betting. So like you can bet $10 or nothing, right? Or stuff like that. So yeah, did you know that in New Jersey they can't ban you if you count cards? True facts. True facts. They can, however, make your life more difficult. Let's take a look at this YouTube video. I won't put it on stream, but I'll take a look at it because we'll see what it has to teach. I don't know if I'm going to be able to see what I need to see to be able to answer the question, but we can at least take a look, all right? So let's at least take a look and see if I can see what I need to see to be able to answer this question of what this person is doing. We'll give it a shot. That seems only fair. Let's take a look. Glock bump fire. Now, what am I? Oh, there's no way I'm going to be able to see what I'm seeing precisely enough. This is at 2 minutes and 54 seconds. Yeah, let's see what I'm seeing here. Let's go at 250. Turn this volume down a little. Yeah, I can't really see what I need to see see how he's manipulating the trigger. But yeah, even if he is bump firing it, I don't think that means that the ATF can't regulate tools that also would allow you to do this, right? Just because a skilled person can do it doesn't mean the ATF. I don't think it doesn't quite follow, you know. Could we get our take on bullet buttons? I don't know what a bullet button is. That's a California thing, right? Yeah, some sort of California bullshit. It's a device which user removes the magazine and semi-auto, replacing the magazine release with a block which forces the user to remove the magazine by using a tool. Yeah, I can't really speak to that because that's some California specific bullshit, and I don't know California law that well. You're reminded of the guy who can make tones to make free calls. What was his name? Who was Captain Crunch? Yeah, but what is his actual name? Can I remember? That'd be real cool if I could remember who Captain Crunch was. I got nothing. At what point does a limitation of firearms become illegal by a Second Amendment alone? Good question. We don't have enough case law to answer that question. I don't know. We don't have enough answer. I don't know. You bump fire, you basically hold the gun loosely against your shoulder so it recoils, it hits, bounces. Yeah, okay. So I don't think it goes to where you want to go though. Yeah, I can't comment about California specific. Mitnick? That sounds right. Kevin Mitnick? Oh, Joe the Whistler. Yeah, Kevin Mitnick also was famous for that. Yeah, I remember Kevin Mitnick, yeah. I remember his story. He was banned from using computers for 10 years. Didn't they tell the judge that he could whistle the missile codes into a payphone? I seem to remember that was what they told the judge. They told the judge that Kevin Mitnick was so good he could pick up any payphone and whistle the code to launch a nuclear missile. Which, if that's true, we have bigger problems, would be my response. But apparently the judge bought that. Yeah, good times. Laws are draconian. The law being draconian doesn't mean that it's not legal. That's a wholly separate problem, man. You can think they're draconian. I'm just here to tell you what the law is. I'm not here to make you happy. I'm here to depress the shit out of you by telling you all the things that you can't do. I'm here to ruin your day. Sorry. Matthew Lillard in Hackers. Oh, I don't remember Hackers that well. And Captain Crunch was the 2600. Yeah, that's right. He didn't whistle the code. That's right. You're right. Yeah, he was the guy who got the 2600 whistle out of the box of Captain Crunch. Right. Okay. Made a mistake on that one. You're right. A little bit. Forgot my freaking history a little bit there for a second. Sorry about that. Yeah, I can't forget my history a little bit. Oh well. I think we're good for now. Gun laws are written by people who are intentionally ignorant, actively racist, and classist, scared of an armed populace. Yeah, that might very well be true. All those things may be true. Not necessarily disputing any of those things. Yeah, My argument was that the bump stock is regulated. Bump stock is possible without an external tool. Therefore, the tool can't be regulated. Yeah, I don't know that follows. Again, that's like the examples that I was providing. It's like, if a person could crack a safe without any tools, it prevents you from regulating the tool. If a person could whistle into a phone the codes to make long distance calls, it prevents you from making a blue box. If a person could make a bong out of a potato, it prevents you from regulating things that are purposeful for that purpose. I don't think it quite follows that a tool that you can find a tool that you can use for that purpose prevents an agency from regulating tools that are specifically designed for that purpose. I don't think that works logically. Although it's a nice thought, but I don't think it works. Can we use the 10th Amendment to regulate federal agencies? Yeah, good luck with that. The 9th and 10th Amendments are kind of both. Well, the 10th Amendment is a bit of a truism, so it doesn't really go anywhere. And the 9th Amendment, if you're relying on the 9th Amendment, good fucking luck. Yeah, My wife and I have never had a good experience if we bring up the law. Yeah, I don't think that logic quite works. Thanks for the $35 worth of super chats. That's actually very generous of you all. Thank you very much. Did I see the shoestring letter the agency issued? I did not see the agency issued a shoestring letter. Did they really issue a letter about shoestrings? That's hilarious. That's hilarious. Hold on. They really issue a letter about shoestrings? Hold on. Apparently. September 2004. Oh my God. That's hilarious. I didn't know that. I was pretty deep into my firearms lore, but you got me one that I didn't know. You got me one I didn't know. Yeah. I'm going to see if I can find this original letter so I can read this too. This is good shit. It's not every day that I'm exposed to something about firearms I didn't know. Here's the official letter. This is good. I can't see the date on this thing. Oh, yes, I can. September the 30th of 2004. Dear Mr. Blakely, this refers your letter of February 6, 2004 to the Bureau, in which you inquired about the legality of a small section of string intended to be used for the means for increasing the cyclic rate of a semi-automatic rifle. As you may be aware, the National Firearms Act defines machine gun to include the following. Blah, blah, blah. In 1996, the Bureau examined and classified a 14-inch long shoestring with a loop at each end. The string was attached to the cocking handle of a semi-rifle that was looped around the trigger. The device caused the weapon to fire repeatedly. Because the gun was designed and intended to be converted to a machine gun, the Bureau determined it was a machine gun. Wow. I did not know that. And then they wrote a letter in 2007, June 25th, 2000. Dear Mr. Blakely, on February 6, 2004, you wrote a letter to the Firearms Technology Branch of the ATF inquiring about the legality of a small section of string used for the means of increasing the cyclic rate. We responded to the letter in 2014. Upon further review, we've determined the string by itself is not whether or not there are loops tied at each end. However, when a string is added to semi fire as you propose to increase the cyclic rate, the result is a firearm that fires automatically and consequently would be fired as a machine gun. So the string by itself is not, but the moment it touches the gun, man, yeah, it is. Love it. It's great. So yeah, that stick that you were talking about, guys, that stick that you were planning on using, the moment it touches the firearm, man, you're hosed. To the extent that ATF letter is inconsistent with this letter, they're hereby overruled. Wow. Nice. That's good stuff. I didn't know that one. That's a nice one. Good stuff. Did you happen to see my request for a final opinion review? March 10th live stream. Well, let me check Discord and see if it's in my list. I don't remember jack shit. I barely remember what happened yesterday. I mean, about, this kind of, yeah. I know a lot of law vaguely. Like, I know a lot of law, like, I can't exactly place exactly what it is, but, I know enough to, like, be able to find it again. But that ATF letter I didn't know about, like, It's like it'd be the equivalent of like me saying like, "Oh, I know this. I read this in a case one prayer," but me not being able to quote the case. I sometimes can't quote chapter and verse, but I sometimes know. It's like, oh yeah, I know there's an opinion that exists. I've read it. What opinion is that? I have no fucking clue. Where am I looking for? What's for a case that says that? What case is this? Yeah. Let's see. From the 10th. Who's asking me? Q squared is. Yes. Susan B. Anthony List Coalition to oppose to taxes versus Stephen Duris. Yeah. I need to do a whole bunch of these cases because I'm like, so I need to do FCC versus Pacifica. No, I did that, didn't I? No, I didn't because, or did I do that? Or I tried to do it. I'm confused. Did I do FCC versus Pacifica? I think I got frustrated and gave up. Taylor versus Rojas, Barnhart versus Thomas. No, I did some of this stuff. Packingham versus North Carolina. Susan B. List, Sessions versus Dema. I have to figure out which of these done, but yeah, I see it on the list. May is Panama City Beach. Yeah, I need to search my notes and stuff because I barely remember what I do half the time, and I need to still edit stuff from the 13th and 14th from February. And my editing's behind. FCC versus Pacifica. Yeah. I probably need to. I need to finish the editing on the 13th and 14th, and then I need to figure out like the videos that I've edited that I need to be edited because I don't even know what they are anymore. I lost my editors, so I have to go back through and figure out like what videos I've edited and what ones I haven't. So I don't know if I'll stream tomorrow. I'll try because I didn't stream last week, but I got some editing to do, and then I've got to go through and figure out which streams I have to edit from the past, you know? I'm having a bad day over here. I did, however, go to the store and buy like 32 cans of Guinness, so that's nice. And some wine and some gin. So, good times. I didn't know about the shoestring thing. That's good. All right, I'm going to be on tomorrow. I'll probably stream for a little bit. Probably won't be a super intense stream. Probably like 3 or 4 cases or something. Keep my editing down. And then I'm going to edit that. I'm going to edit the ones from February. And then I'm going to, over this week, try to figure out which episodes need to be edited. And yeah, this is going to be, a pain in the ass. Yeah, well, I'm not really, strictly speaking, having a bad day today. That was kind of a misstatement. I'm having a bad period in the channel because I'm trying to recover from complete cluster of crap that everyone who is on the Discord knows all too well about, and we're not going to talk about that anymore. So, yeah. I did a batch record for FCC Pacifica, but didn't finish editing it. That's quite possible. Yeah, it's quite possible there's a whole bunch of shit I haven't edited because I have not kept track really well. So I'll figure it out eventually. I'm going to sign off. We've been talking about this enough. But we had fun. Didn't we have fun? We had fun together. We had a good time together. I got to tell you that the law sucks. And you told me that's not a reasonable reading of the law. And then I told you how much the law sucks. Told you, yes, it is. And it doesn't make sense. I'm like, welcome to my world. And here we are. I'm going to sign off. If you're not already subscribed, please subscribe. If you haven't liked this video, why not? You should like this video. We're having a good time together. And did you know for 99 cents a month, you too can become a member of the channel? It's true. you can click the link and become a member, help support the channel. Also, incidentally, not that I think anyone's used it yet, but there is a link to donate not through YouTube. You can donate through Streamlabs and PayPal now. So, there's that. Anyways, I'm going to head off. Have a good time. Bye.